Hello, my name is Corey Shelton. I'm with the Fire Investigator's Office, and I wanted to take a few moments to describe to the jury in regards to the fire on 614 May Street. I wanted to provide for a few moments, take a few moments, and provide a few pieces of evidence as to why I feel as though uh, the fire investigators had every right to have taken themselves to investigate the scene after the fire had been extinguished. So, in initial reports, they said the fire that had came out around 1:17 at 614 May Street. It was a first alarm fire. The first due engine basically proceeded in. They forced open a door. The crews advanced. There's minor smoke conditions with good visibility through the house, and they had heavy to moderate smoke conditions in the living room area, giving it near zero visibility. Fast forward, so as the fire crews were loading up and finishing their fire attack, they received another fire call alarm that was a few blocks away that they had to rush to go take initial um, fire attack on as well. And so that kind of left the scene unsecured. At that time, the fire investigators came by a little bit later to do their initial investigation to figure out if they could rule out any type of arson at that time. And about the same time, which is when the owners of the home and the family showed up with their lawyer stating that was against the Fourth Amendment right. So, with that said, I've gathered a couple different court cases from the Supreme Court on one being, and I'm referring to my notes here that I have, these will all links be included in with my handout. So there's one being Michigan versus Tyler. In this one, this was in 1978 was actually when this was done. And so basically, a fire broke out, and it related to the fire investigator themselves needing to be the ones to apply for a warrant in order to be able to do an investigation. But this was based upon the fact that they needed to come at a later date to do the investigation. So, in the instance of a fire or anything like that, and this is my other case, would be Michigan versus Clifford. In this case, one of the fire investigators came out and they sort of had the same concept as this. This was also done in 1984, and the Fourth Amendment was claimed that was needed to be able to do a search warrant, and that was needed to be able to do a fire investigation and whatnot. But according to Michigan versus Clifford, uh, the judge ruled that in a reasonable amount of time, the fire investigator has available to them after a fire has been extinguished or a fire circumstance has occurred. And so this would require sufficient investigation to be able to come through and say that to judge whether or not they could charge the homeowners with arson. So therefore, I fully believe that it is not against the Fourth Amendment right for these homeowners to be suing or to be saying that they're in violation, the fire investigators are in violation. So a couple of other things that I would be questioning was what would be the family history of this? What's their employment history? It seemed a little odd that they showed up right after the fire started, left the scene, and then showed back up with a lawyer pretty quickly after the fire had been extinguished. So why that would be questions that I would pursue. Also, what's their, like I said, what is their rent history? Do they rent or own this home? What's their employment history? Do they have any criminal records already? So those are other things that I would be pertaining to investigations due to the fact of it does seem suspicious with all of the markers found. Based on this, there was a melted device that appeared to be in a pour pattern that appeared to be behind a TV in the kitchen. So these samples were collected, and these are very much needed pieces of evidence to be able to go and send off to a lab to be able to figure out what was used, if there was anything used in determining if this fire was arson or not. So I asked the judge and jury to allow that to happen. Thank you.